There'll be a minute. Good morning, and thank you for your patience. We have one person who is appearing hybrid today. We've allowed an emergency motion for that to happen, and I'd like to thank everybody for helping us facilitate the argument today. So the name of the case is DC and Another versus Father. As you all know, the case is impounded, so we expect you to be careful about using any names. Actually, don't use any names, to be more specific. The case number is 2023-0339. Counselor, can you hear me?
Yes, Your Honor, thank you.
Now, I do know, Counselor, that you don't have a timer, or maybe you have something set up for yourself so you would know what your time is, but when you have a minute and a half, if you go that long, I'll let you know.
Thank you.
Okay. You may proceed.
Morning, Your Honor. Jennifer DeFeo. I represent the father herein. It is a pleasure to be here this morning in an effort to get this matter vacated and remanded to the juvenile court. We are requesting, Your Honors, that this matter be vacated, opposed to being reversed due to the substantial constitutional violations that have occurred in this case. The constitutional violations involve both a constructive denial of counsel as well as some egregious errors of law made by the judge. The constructive denial, Your Honors, is based upon the fact that his trial counsel did not represent him before, during, or after the representation. Counsel herself conceded that she did not represent him appropriately. From her opening statements to the court, and even a step before that, when she failed to object to the dismissal of the petition for guardianship, she did nothing. What she did instead was prejudice her client's case. Because this is a constructive denial, it does not even have to show prejudice. But I want to explain to the court a couple of things that she said that are very telling. In her closing argument, she admitted that we don't have an expert to testify on behalf of the father that the child should have any other or different outcome. I don't know how much telling it could be in that statement. She does state, Your Honors, that she is unprepared. She doesn't want to go forward. Mm-hmm. She states that she wants to withdraw or have a continuance. She doesn't want to try these cases anymore, Your Honor, which means that being there that day is something she does not want to do. She failed to appear for the first trial.
Can you explain to me, I'm sorry to interrupt, can you hear me?
No problem. Yes, I can.
That first trial, August 21, was that supposed to be the father's trial as well?
Yes, it was, Your Honor. Absolutely.
And what happened? I mean, we can check some docket somewhere maybe, but she just didn't show up, and of course neither did the... Is that what happened?
Yes, Your Honor, she did not show up. She claimed that
the judge did what?
The judge accepted her explanation after the trial that she had mistaken the date that it was supposed to occur. But Your Honor, she also failed to show up at the final pretrial conference. So this is an attorney who's put zero effort. What doesn't matter, she failed to inform her client about a critical Zoom meeting that would allow him to reestablish visits with his daughter. She acknowledges that she didn't explain to him what was going on. He didn't even understand, Your Honors, that he was on trial that day. When they were proceeding to trial, father had no idea that they were not proceeding forward on having his mother.
Well, that's a credibility question, though, isn't it? That part, what he knew or didn't know.
Okay, but the judge didn't know either, Your Honor, nor did DCF. The judge states, I don't know whether we're proceeding forward on unfitness or a competing plan. DCF says, wait a minute, what do you mean there's a competing plan? I didn't get notice of that. So, Your Honor, there is nothing that this attorney did to help proceed this case forward. She admitted that she was considering her father. She admitted that she hadn't spoken to him in months. She didn't call a single witness, not even the person that she claims was a competing plan. And then when challenged on that, she says, oh, well, she'll be a great support for father. What we're facing here is zero representation. She was so desperate, Your Honors, that she said to the judge, I'm going to have my client do his own closing argument. And when this happened, father stated, oh, okay, I wasn't prepared to do something like that. Can I have a few minutes to prepare? This woman, for her own personal reasons, was not physically or mentally present during this case.
I wanted to ask you a question.
Absolutely.
It may have been helpful to hear from counsel about some of those reasons with an affidavit. Was there consideration for a motion for new trial in the juvenile court?
No, Your Honor, the single justice denied our request to have this sent before the juvenile court for a motion for new trial. I repeatedly requested, and I did submit an affidavit with the motion to stay and the motion for a new trial, that I reached out to her and asked her for an affidavit, and she refused to provide one. So again, Your Honor, at all stages, this attorney has not represented the interests of father.
Can you back up just for a moment so I can understand? Because even without an affidavit from trial counsel, a motion for a new trial would have enabled the trial judge to make a ruling. And you're saying that you were precluded from doing that as a result of the motion or the ruling of the single justice?
Your Honor, my understanding, and I do apologize if I'm incorrect, is that once I file the motion to stay, if it has been denied, I do not have the authority to go forward and file the motion for a new trial with the juvenile court.
Well,
that was my understanding.
The lower court has no jurisdiction unless you get leave. Once you file the notice of appeal, the case is here, not there.
Correct.
You're correct.
So, Your Honors, with that constructive denial, it voids this decision. And with the voidance of it, the only solution is to have this remanded back down. And in addition to the constitutional deprivation of his due process rights for counsel, the judge in the trial court also made an error of law. Father was desperately trying to explain to the court that a lot of the issues were not something that he was even aware of. He was trying to explain that I tried to reach my trial counsel. I tried to comply with these things. I asked her for assistance, and instead of helping me, she just ignored me. And in the affidavit from father, he explains that he felt as though she wasn't interested in him as a client. He even says that during his testimony, and again, yes, it goes to his credibility, but he states to the judge that he believes that her difficulty with her own father has trickled down to him, and that he felt as though she was taking out her displeasure, her whatever the adjective you'd like to use, about her father on him. That is a conflict. It is a conflict she personally may have with this particular man. And I think that her refusal to communicate with him shows that. When you have an attorney who does nothing, Your Honor, and please understand, she didn't file a single motion. Even when the judge says to her, if you have an objection to this, file a motion in limine. She doesn't do it. When she asks a question about the guardian ad litem, the judge says, file a motion in limine, or call the guardian ad litem, or inquire of your client as that. She didn't do any of those three things. This is a constructive denial of counsel. She also, Your Honors, throughout the actual trial itself, continues to say to the judge, I can't do this. I can't do this. I am not prepared. My client is not prepared. Now we're breaking down in communication. The judge never inquires of her, can you give me some specifics? She never inquired of father, do you feel as though she's accurate? None of this was done by the trial judge. All father can say is, in his own defense at the very end is, I had documentation that if anybody would like to go back and look at that documentation that we have, but it wasn't present. It wasn't presented. Those are father's own words. At the beginning of the trial, he says, I have witnesses to call. I don't have my phone with me. Give me the opportunity to get my phone so I can provide the names and telephone numbers, the ability to subpoena in these witnesses. Why weren't they already done? Because trial counsel conceded I didn't even get a witness list from him. I don't know who he wants to call. He never prepared her client to testify. The woman, the paternal grandmother who was petitioning for this child, was not called as a witness. That to me is just astounding. There were days left in the trial, and she didn't do it. She never conferred with her client, and even on the morning of trial, when DCF calls him as their first witness, she says to the judge, he might have a Fifth Amendment right. I should probably go and talk to him about it so that he understands what these rights are. I mean, how can you get to that point, the moment of trial, when your client's about to testify and say, I probably should talk to him. I don't know how much more of a constructive denial that could exist. She even implies, that I'm just too tired to do this. I just came off a year-long trial. I am the one who's asking for the continuance. I am asking to withdraw. After she does that, father says, wow, I don't know we're here for trial. Can we have a brief continuance so that I can get my ducks in a row? The judge did say to him, well, you knew about this date, and his response was, but I was told I had to meet with the guardian ad litem before we would go to trial, and that never happened. And that was one of the issues. Why wasn't he meeting with the guardian ad litem? And the judge said, figure it out. You have multiple ways to figure it out. But she didn't do it, Your Honors. And it's not clear what she actually did in this case to promote her representation of him. At the end of the trial, she says, okay, I'm going to file some findings. When are they due? She didn't even do that. She offered nothing. So while she, yes, made some objections, most of them were not supported. They were for leading questions. She couldn't even articulate several of her objections. She misquoted case law as to why certain documents should come in.
Go ahead, please.
I just want to direct your attention a little bit, assuming, of course, that your description of counsel's performance is such that the first prong of Safarian is met. All right. So thereafter, there are instances in which your client testified, and the trial judge found the testimony simply not credible. Can we not look at that independently in terms of determining whether or not something else would have been able to been accomplished by an attorney that was more present and had been more involved with your client?
Your Honor, how can a client accurately testify when he's not been prepared to do so? He hadn't spoken to his attorney in months. He hadn't had a private conversation with her in probably since September prior to this trial. So we're talking a substantial amount of time. The last time they even spoke briefly was during a foster review. And they didn't have a private conversation after that.
Again, there is, of course, substantial evidence regarding your client's ability to parent, the fact that he had a lengthy criminal history, the situation with the mother of the child, etc. Much of that was undisputed, even by your client, and to the extent that some of those factors were minimized or there was a disagreement with respect to facts, the judge did not find your client's testimony credible. And your yellow light. Let me just tell you that your yellow light is on, just so you know. Okay.
Okay. So, Your Honor, under constructive denial, we don't have to show prejudice. Under Commonwealth versus Valentine, But if we were to show the prejudice, if we were to address the second prong, the judge needs to make a fair assessment of the facts. There's no expert witness to show that he has the ability to bond with this child further. He testified, which the judge sort of glossed over, that he is prepared. He understands this child's needs. The mother was able to get in statements through records. He didn't have the right to cross-examine her. He was denied that constitutional right to confront her because his attorney didn't call her. Yes, he has a criminal record, there's no dispute about that. But the incident in which the child was allegedly traumatized occurred in 2017. That particular case was dismissed. It was dismissed. So, what's the prejudice from that? The prejudice is, again, brought upon by his inability to confront her, which is again another constitutional violation. The other prejudice occurs, even from counsel's own statement, is she didn't rebut anything. He's not the perfect man. He doesn't have to be the perfect man. He said, I will take the anger management class again, the intimate partner class again, but I can't afford it. Help me pay for it. He says, I know I need more help. He says, give me the ACVO program, which the child's expert said everybody should participate in. He said, let me have therapy with my child. They didn't do that. So while
I'm
this
going to have to
may
tell you that
be...
you're now over your time, but
Okay.
you've answered my question.
Yes.
And of course, all of your arguments in your brief are not waived. We'll still consider all of them. But let me just check with the panel to see if they have any follow-up questions for you, okay?
Thank you.
Nope, the panel does not have any questions, and so I'll stick to the rules and say that you are, that your argument is completed and move now to the other side. Thank you very much.
Thank you, Your Honors.
And if I'm not mistaken, we have a time that's being split. How much time are you taking?
7.5 minutes.
7.5 minutes? Perfect. Okay, thank you.
Good morning. May it please the court. Matthew Price on behalf of the Department for Children and Families. The department is asking this court to affirm the decision of the lower court of the termination of father's parental rights.
Can I ask you just to talk a little bit closer, or maybe pull the microphone towards you? Thank you.
There was overwhelming evidence of father's unfitness.
He doesn't contest unfitness.
I'm sorry?
He's not contesting unfitness, he's contesting his denial of counsel. Can you address that, please?
Yes, Your Honor. Trial counsel was not ineffective. Trial counsel, her performance was not measurably below what could be expected from an ordinary fallible lawyer, and he was not deprived of a
Have you ever
substantial
heard
defense.
of a lawyer going to trial who hasn't talked to their client in 3 months, who hasn't prepared him to be a witness, who says herself she isn't prepared? Have you ever seen that? Because I haven't.
The 3 months prior to the trial, father was incarcerated. Prior to his incarceration, they were in regular contact. The father said that, as well as the trial counsel.
But they didn't prepare for trial.
She said she was preparing for trial with him. They were strategizing, and she put on defense for him.
She said that she hadn't prepared him and wasn't prepared herself. Right? I mean, that's what she was saying. Maybe she's lying, but that's what she was saying to the judge.
Well, she said to the judge that she didn't want to prejudice her client.
Because she was unprepared, you mean?
When
Is there any disagreement about that? I just want to be sure in terms of the record. Do you disagree that the lawyer said that she was not prepared?
I would not disagree with that. She also told the court she was ready to challenge the department's case.
Okay.
Did she know what the competing plan was?
The grandmother's,
Yeah, did she know anything about that?
she put forward that was the competing plan for father.
How did she do that? What did she provide? She just said that sentence?
She presented
Did she talk about what a great home it would be for the child?
the trial court had findings as far as what,
I'm asking what the lawyer did, because the problem here, it seems to me, they're not contesting unfitness. They're saying he didn't have a lawyer, as I see it.
he did have a lawyer, Your Honor. The lawyer had a strategy. She presented a case. She was active throughout the case.
And what was her goal, would you say, in this hearing? What was she trying to get to happen at the trial?
She was trying to present father as a fit father.
Okay,
She-
that's not, he even said, I'm not asking to have the child put at my house. I want my mother to care for the child. So why was she pushing fitness instead of pushing competing plan?
Well, in addition to that, she was trying to undermine the department's case. And she did that by attacking the department's having not followed its own policies. She tried to present father as a good father to his children.
Yeah,
that
he's
he
not,
met-
right? He didn't
Well-
contest that. He himself, I don't know why he's talking, there's this weird thing that happens throughout this where suddenly he's not on the stand, but he's just talking to the judge, even though he's represented by counsel, right? And he says things like, well, at the beginning, he says, I need to get my ducks in a row and this and that. But he says, I'm not asking for, maybe he does contest fitness or not fitness, but he's not asking. Really what he's saying is, don't terminate my parental rights, do this plan. As I see it, although, of course, he wasn't prepared for trial, so I can't say what he would have asked for had he prepared for trial. I'm just trying to figure out how this is an ordinary fallible lawyer, not something below that.
Well, I think that regardless of what the trial counsel's efforts were, she was confronted with overwhelming evidence. Thereby, there was no prejudice to father, regardless of what she did.
So when
But-
people are really guilty, they don't need a lawyer.
No, he needed a lawyer. He had a lawyer.
Didn't need a lawyer.
She was active throughout the case. She put on a case. She defended him. She, what father does,
What evidence of fitness did she put in?
that he did his service plans, that he had some visits with the child, some of which were facilitated by the department while he was incarcerated, that he was a good parent to his other children.
What evidence did she put in of that? What evidence did she put in that he was a good parent to his other children?
Father's testimony, when
Well, father was called by the defendant, right?
Father was called-
by DCF, by the plaintiff.
Yeah, but he testified in a narrative form, essentially on cross-examination, for 2.5 days, and was able to present what he wanted to present to the court. The court, in many instances, didn't find him credible and made her decision based on that. But the performance of the trial counsel was not measurably below an ordinary fallible attorney, and there was no prejudice to him.
Did she put in the documentation? I know the judge found he did it anyway, but did she put in the documentation of all these programs he completed?
No, but that was not, that did not prejudice.
Wouldn't an ordinary fallible lawyer put that in?
No, but the judge considered it, and she considered it in his favor, and she still found
Well,
him
you're saying no
unfit.
prejudice, but I'm asking if an ordinary lawyer would put in evidence.
It's difficult to say what
Well,
she...
you've seen DCF trials before. Do they usually?
Well, I can't tell you what the attorney was thinking, why she put in evidence or didn't put in evidence, because there's no
She said she
affidavit
hadn't
from her.
prepared.
I'm sorry?
She said she hadn't prepared. That seems to be why she didn't have any evidence or a witness list.
How she characterized herself was considered by the judge on the third day. The judge factored in what she said when she was concerned about prejudicing her client. But the judge also factored in the totality of what was going on and the context of the case. And she factored in what she had seen the performance of the trial counsel do in 2.5 days. And she found that was, in her words, she had done a fine job. And there was not a concern as far as how she was representing the client. The judge didn't see any indication that she wasn't capable of representing the client.
Additional questions?
I mean, they're not really questions. They're observations, so no.
Okay.
No.
One moment, please. Question. All right. Your time is up. Thank you for your argument.
Thank you very much, Your Honors.
Good morning. Good morning, Your Honors. Daniel Katz for the child. Sorry, did you have a?
No, I don't. Go ahead.
Oh, okay. Prior to the child being born, father punched the mother in the stomach, and he said he did not want a child. After the child was born, there is a lot of evidence of violence from the father to the mother, also evidence that the father encouraged other men to hit the mother. One situation in the record shows that the child was present and crying when the father choked the mother.
And that was the incident that your sister has explained to us resulted in a criminal charge that was later dismissed, right?
There have been some charges which have been dismissed and some which have not. And I think the key thing is to recognize that at the time of trial, well, first let's go back.
Well, could you answer my question? Am I correct?
even if
correct? That case was dismissed.
Yeah, even if that was dismissed.
I know there's lots of reasons for dismissal. I'm just trying to get the facts straight in terms of the history of the case.
Yeah. Even if that case is dismissed, what the SJC says in Vuono and its progeny.
Sure, I understand, but that case was dismissed just
Yeah.
because, and the mother didn't testify at this trial. So that's just wanted to have that confirmed.
Right, but the fact still remains that the child was present, and if we learn anything, not that we need the SJC or this court, quite frankly, to tell us that being present for domestic violence is harmful to a child, but there you go. It's there in the law. The fact remains that at the time of trial, there were other open charges that father had, including not against this mother, but domestic violence issues. And what's very telling is that from the words of the father himself, when questioned, yes, I guess I did not learn from the programs. So whether you have one, whether you have 20 certificates of completing anger management, completing domestic violence cases, the bottom line is, and we learn from the case law, here's your insufficiency, your deficiency, violence, domestic violence, at least once in front of the child. Okay, offered programs, have you made any progress? It's undisputed that the father here has made zero progress and even admitted it himself. So no matter what lawyer was here, Clarence Darrow or whomever, the evidence is so overwhelming that this man was unable to contain his anger. I mean, the image of punching a woman while she is pregnant. Let that stick in your minds. The image of choking the mother of this child. Let that stick in your mind. And then for the father to say that because this lawyer and her conduct may well have fallen below, clearly, not being prepared in many ways. But if Aziza teaches us anything, the fact that this man is unable to control his violence, no lawyer, I am sure, could have done any better given the faults of this lawyer. And let's read from the decision my sister quotes about, this is from Commonwealth v. Valentine. Both of these cases, an understanding that constructive denials of counsel rising to a level of structural error occur only where the defendant essentially is denied the assistance of any qualified attorney who could theoretically represent him in a way that does not undermine our trust in the adversary system. Well, here in the adversary system, the evidence came out and the father was able to testify about, hey, what have you learned from these programs you supposedly have been in, and maybe your attorney failed at presenting the court with the certificates. No certificate changed this man. No certificate, no amount of classes taught him you don't hit a woman like that. You don't punch a woman. You don't choke a woman in front of your child.
Can I ask you a question that goes a little beyond the record?
Yes, Your Honor.
Have you spoken recently with your client or been in touch with your client?
Yes, Your Honor. I met with her yesterday.
Okay.
And if you would...
I don't want to hear what she said or anything like that. Is she still in the placement she was in at the time of trial?
Okay. Now I know I go through this protocol because there has been a change. So this is off the record, and Your Honor is telling me you want to hear what's off the record.
That's correct.
Okay. So tragically, there was a situation with the pre-adoptive parents. I do not know the details, but I will tell you as much as I know, and then you'll tell me when to stop or not. There was an incident where a stick was involved by the pre-adoptive foster father, not against my client, but against another child in the house. A neighbor contacted DCF. DCF came, removed both my client and another foster kid. I don't know whether that kid was pre-adoptive or not. Did not remove the kid that was actually hit or brushed up against. Okay. The kid, she had been there for 5 years. Sadly, and I know we're not supposed to get emotionally involved, but this breaks my heart because she is still pining for them. Unfortunately, she was homeschooled there, and at the time of trial, she actually had met the first grade standards. But she's undergoing an IEP, but unfortunately, she is now back in the third grade, being 9 or 10 years old.
She's currently in a new placement? She's currently staying with a different family?
Yes, she has now a new placement, and she definitely still, can I continue? She definitely still expresses fear of the father, and
Okay. I think that you can stop right
Okay,
there,
sorry.
all right? We'll just, and I just want to assure counsel for the father that having this updated information is just to exactly that, for us to have a context, but we do not rely on any of those allegations with respect to recent feelings about her biological parents. Okay?
Can I just ask, the new placement is not currently a pre-adoptive placement, it's a foster home?
There's hope from both DCF and the mother that it will be pre-adoptive. I know she's technically not my client, she's the department's, but she does want to adopt. It's a relatively new placement, so honestly, I don't
Okay.
know.
No, that's fine.
All right. Thank you for that. There may be additional questions about the issues? No? And, all right, thank you very much for your argument.
Thank you.
All right, so the argument is concluded. You can, what is the prompt? I think it just says end Zoom meeting, right? So you may end, and thank you very much. And we've heard from everybody, so I'll be calling the next case now. Thank you.
Thank you, Your Honors.
Thank you. Leave meeting, that's the term I was looking for.